Room.
Let's take three.
What we're discussing this morning is the developments in the law relating to the doctrine of penalties as a result of the very recent decision of the Supreme Court in London
Formerly the House of Lords.
In Cavendish Square Holding versus Talai El Makdessi. Now, what is interesting about the Andrews and ANZ, would it be best to start with a summary of what the law was before Andrews and ANZ and why it is that that decision has certainly been criticised?
Yes.
Okay.
Prior to Andrews and ANZ, which was handed down by the High Court in 2012, the law in relation to the doctrine of penalties appeared to be settled. It required a consideration of whether the agreed stipulated amount that the contract breaker agreed to pay on breach of the contract represented a genuine pre-estimate of the damages. That was the law, and that was what the state of the law as it had been for many, many, many years. But then in Andrews and ANZ, the High Court said, after an extensive review of the equitable jurisdiction, the High Court decided that, in fact, the law of penalties was not only restricted to circumstances where there had been a breach of contract. The High Court held that equitable jurisdiction had a part to play, and that the doctrine of penalties could apply in a situation where there had not been a breach of contract. That was the first surprise. And the second surprise was that they held that even if a clause was held or payment was held to be a penalty, it could be partly enforced to the extent that the amount...
to the extent that it could be apportioned to the extent that it was enforceable. And that was also the subject of criticism in the Supreme Court decision. In a sense, it was a quite obscure approach, the second approach.
Yes, because the High Court talked about primary stipulations, collateral stipulations, part enforcement, and there's the Latin phrase inter horum.
That's right.
And even though I've now looked at that phrase many, many times, that contractual, their rendition of what they say the doctrine of penalties now involves, it's very hard to understand, even though Justice Gordon, in the federal court case of
Bacciocco, that will do,
provided us with a 6-step process.
Very complicated and clearly wrestling with, if you like, the not precise guidelines given in Andrews and ANZ.
Yes.
And I don't think it's useful to go through those points. The full federal court overturned her decision.
But not the 6 steps that she came up with. But it might be useful just to tell our viewers what those 6 steps involved, according to Justice Gordon, seeing as she's now in the High Court.
Yes, and she may sit on the very case from which she's being appealed.
She won't.
She won't, of course, I know, but it'd be very interesting to say I was wrong. I can fix it all up. These are the points that she said. First, you have to identify the terms and inherent circumstances of the contract. Secondly, and you've got to look at that at the time of making the contract.
Yes.
You've got to identify the event or transaction which gives rise to the imposition of the stipulation. You've then got to identify whether the stipulation is payable on a breach of contract, necessary at law but not in equity, at least according to the High Court.
Yes.
Identify whether in substance the stipulation is collateral to a primary stipulation in favour of one party, and the collateral stipulation upon the failure of the primary stipulations imposes upon the other party an additional detriment in the nature of a security for, or in terrorem of, the satisfaction of the primary stipulation. Then, if the last answers to the last questions, the last 2 questions are yes, then you've got to ask whether the sum stipulated was a genuine pre-estimate of damage or extravagant and unconscionable in comparison with the greatest loss that the law could be proved. And the last step was that the sum stipulated, if it's not a pre-estimate of damage or is extravagant and unconscionable, the amount cannot be enforced, at least to the extent that it exceeds the amount which is assessed. And in that case, she made an assessment of what the actual loss would be to the bank in that instance.
Which is extraordinary, because for a judge to be making those assessments of costs. But what she's trying to do there, she's divided the whole contractual obligation to a primary stipulation, which is the primary, as I see it, the primary promise that the parties have made to each other.
Yes.
Then she talks about collateral stipulation, and as the Supreme Court say, I think it was Lord Sumption says, that the moment you talk about a primary stipulation and a collateral stipulation with an amount of money payable as a collateral stipulation, that it appears to implicitly imply that there has been a breach of the primary stipulation.
That's right. And so that although the analysis that Lord Sumpton goes through is to say, well, there must be this an obligation which has not been performed.
That's right,
and
which leads to the collateral obligation.
So, which is, if you like, contradicting the approach taken by the High Court.
That's right.
Yeah. Now, I think the really most interesting thing about the Supreme Court's current decision is that on analysis, we will now, if we were to adopt the approach of the Supreme Court, we have a much clearer approach to how you assess and what you're assessing in relation to whether or not an amount agreed is a penalty.
But what did you like? There were some aspects of the Supreme Court's decision that I really liked, the way they talked about sometimes always you have to look at the commercial interests of the party and what each party is trying to protect when they enter into that contract.
Yes.
And sometimes, even though that commercial interest or a breach of that contract, there can't be a genuine pre-estimate of the damage suffered. You look at the commercial interest of the party as a whole and see whether that stipulated sum, how that compares with the commercial interest the parties are trying to protect.
Yeah,
you see it?
Yeah, I do. And I think the Lord Hodge, I think in paragraphs 249 through to 255, makes it abundantly clear that what you're assessing is whether the provision is exorbitant or unconscionable. You have to have regard to what are the legitimate interests, the commercial or otherwise, which the innocent party is seeking to protect. Now, I think that's a better way of looking at it than to say it compensates or it's damages and that are properly reflected in the breach. I think the great, I might as well read it. The correct test for a penalty is whether the sum or remedy stipulated as a consequence of a breach of contract is exorbitant or unconscionable when regard is had to the innocent party's interest in the performance of the contract. Where the test is applied to a clause fixing the level of damages to be paid on breach, an extravagant disproportion between the stipulated sum and the highest level of damages that could possibly arise from the breach would amount to a penalty and thus be unenforceable. And he agreed with the other judges to suggest that it rendered the provision unenforceable. It was not only enforceable to the extent that it...
So why don't we tell our viewers, the Supreme Court actually dealt with two cases.
That's right.
The second case dealt with the sum payable by a parker who had parked in a council car park and had exceeded the 2-hour limit. And in those circumstances, the council decreed that if you exceeded your 2-hour parking limit, you had to pay a sum of £85.
That's right.
Now, on no basis could it be said that the £85 constituted a genuine pre-estimate of the damage. But the Supreme Court said that that was not the end of the story. What you needed to look at was exactly what the councils were trying to achieve.
That's right.
And what their purpose was.
And what's their legitimate interest.
That's right. And they, as I recall it, they wanted to provide free parking up to 2 hours.
That's right.
That's right. And the parkers were upset that whether you went over the parking limit by 1 minute or 10 hours, the fee was £85. And they thought that was an instance of why you could say it wasn't a genuine pre-estimate of damage. But the Supreme Court looked at it from a wider perspective.
That's right. Yes.
And looked at the purpose and also considered the fact that it was pretty much standard across all council car parks, really, that once you exceeded that 2-hour limit, it was accepted.
Yes, and I think in taking that approach, there was another English decision which was very much along the same lines as Andrews and ANZ,
Yes.
in which this is the Department of Fair Trading case,
It was
Office of Fair Trading and Abbey National,
Yes.
where again the case dealt with the penalties or the charges which were applied if you overdrew your account or a general cheque was bounced.
Yes.
And they were held not to be penalties. They were simply an agreed consequence of the breach, which was apparent. It was clearly being a breach, there being an obligation not to allow your
That's
account
right.
to go into, except I do it all the time.
But the Supreme Court thought it was relevant that the bank had never agreed to honour bounce checks or to allow your bank account to go into arrears. And so it was never a part of their bargain to honour these charges, and that was relevant in their conclusion, in coming to the conclusion that the charge levied when there was a bank overdraw was not a penalty. Is that how you say
That's right, yeah. But now the other thing,
because isn't that an example of looking at it from the point of view of the overall commercial interests of the parties?
That's right.
And what was actually agreed between the parties?
Yes, and it wasn't really. It's the disproportionality is having regard to the legitimate interests or commercial interests of the parties.
Because sometimes,
which I think is a hell of a lot better way of looking at it than to simply say, are these damages a true and accurate estimate of
because sometimes
the loss?
you can't put a value on it, and it's impossible to value what the monetary consequences of a breach of contract is. And in fact, wasn't it Lord Diplock who said that if a stipulated amount is levied on the breach of contract in a whole range of matters, and some of which can be quantified and others cannot be, didn't he say that was an instance where it was less likely to be a penalty? Why do you think? What do you think the logic behind that is?
I don't know. I'll come back to that.
I don't know either.
I think it's worth going through the 4 steps that they did in fact raise. They said, in determining that the approach taken in Andrews and ANZ wasn't something that was appropriate for English law, in the first place, whilst it was entirely, Andrews' reasoning was entirely historical, it was in fact inconsistent with the law. Certainly the Australian authorities, and didn't explain why it was that they had moved from the position in AMF and Legioni and Haitley, where those highly internationally respected judgments were ignored. Now, the other thing is that the redevelopment, if you like, of the role of equity in the doctrine of penalties. And it's interesting when you consider that what was in fact said in the joint decision in AMF and UDC, the equitable jurisdiction to relieve against penalties, with it on the vine for the simple reason that it offered no prospect of relief, which was not ordinarily available in proceedings to recover stipulated sum or damages. This is the decision of Mason and Wilson. So that the Supreme Court was, if you like, somewhat concerned that the reintroduction of the role of equity in this document.
It had no jurisprudential basis.
Yes.
And in fact, the Supreme Court had regard to the article of Dr. Carter.
Right.
Not Dr. Carter, Professor Carter.
Professor Carter.
And they did refer to the decision. And
Yes.
Professor Carter is now completely vindicated on his views.
But it was.
And in fact, he told me that they had to tone down his anger.
Well, I'm not surprised. By reference, what Laina was referring to was an article by Professor Carter, Wayne Courtney, Elizabeth Peden, Andrew Stewart, and G. Tolhurst. Now, it was 2013-30 JCL, the Journal of Construction and Contract Law, and it's a very angry analysis of ANZ and Andrews.
That's right.
And I think, well, as you say, the Supreme Court has accepted the criticism.
They have. And this paper was referred to during argument.
Yes.
In the Supreme Court.
So that it's the position in Australia is interesting because it, if you like, from a construction point of view, a conventional approach to construction conflicts or disputes about whether or not the damages applied as liquidated damages apply will still go back, I believe, to the pre-Andrews and ANZ. And that case will be confined to extraordinarily narrow circumstances.
That's right. But the pre-Andrews and ANZ positions still apply.
Yeah.
It's just that the High Court has purported to expand
That's right.
the doctrine of penalties to cover situations which don't, they say, amount to a breach of contract, although it's difficult to see how it can't amount to a breach of contract when they're talking about primary and collateral stipulations. And
there is a default of some form, whether or not, and to ignore it as a breach of contract, to say that it can apply as a consequence of the contract, seems to ignore.
So practically, it is difficult to see how this expansion of this doctrine can really apply in real terms.
That's right.
And also the Supreme Court were quite rude, weren't they, about the fact that what the High Court have done is to try to give the court a more supervisory role, where the court now has to review the contracts to see whether what has been agreed or not agreed can also be said to amount to a penalty.
That's right. And the Supreme Court actually gave examples of how broad that jurisdiction would be if it was allowed to, and because of the breadth or the potential breadth of the jurisdiction, they were doubtful as to the accuracy of.
Yes.
And I think for those who are interested, to read the article by Carter really does explain the remarkable change that the High Court's decision involved.
They did, without any justification.
Yeah, and without, if you like, the judicial explanation that one would expect, where you are changing or expanding a doctrine that's been part of the law, common law, certainly the common law of contract, for decades.
So to wrap up, what we have is we still have the pre-existing law on the doctrine of penalties.
Yes, we have.
Breach of contract, not a genuine pre-estimate of damages.
And we have the potential for being able to argue that the approach taken by the Supreme Court allows for a review of the actual interests and the contractual and commercial interests of the parties which are trying to be protected, so that it's a slightly broader analysis than simply assessing whether or not the damages are a genuine pre-estimate. And it allows, if you like, a slightly broader approach, but still confined to the contract. And
still confined to situations of breach, but
that's right.
Assisting the parties in trying to come to terms with whether that amount payable does constitute a penalty in the circumstances of the commercial interests of the party considered at the time of entry into that contract.
Yes, and I think so that from a construction view, it is unlikely that Andrews and ANZ will really have a substantial impact on the arguments. The principles are still defined as they were, but there's been attempts by, there was the paper and suggestion by Davenport that the time bars and conditions precedent could be penalties in relation to Talai claims, which was very loudly squashed by...
What about the idea that a performance bonus for early completion can constitute a penalty?
I don't know that applying any form of common sense that would ever occur. I think an example of how confusing the decision of the High Court in its review of the doctrine is clearly evidenced by the paper by Davenport, I think, where he took up their approach to collateral and different forms of terms, the obligations, to actually suggest that a time bar or a condition precedent could be a penalty when applied to a claim for an extension of time.
Okay. So Ian,
Okay.
out of 5 stars, how do you rate Andrews and ANZ?
I think 2.
A 2?
But I think...
in this instance, I do have to agree with you.
Thank you very much. And I think I'd have to say that...
And how about Cavendish? How many
Cavendish, I think it's definitely a 5-star.
I have to agree with you.
Okay, thank you.